What is up, everybody? How's everybody doing? What's going on, Katie? How you doing?
Good afternoon. Happy Sunday.
Happy Sunday. Your daughter was a little sick, huh? She's maybe feeling better, but you might be now feeling sick soon, you think?
She sneezed or coughed or did both into my mouth. So I still feel okay, but I don't know for how long.
The joys of parenting, folks.
Yep.
Before I forget, Katie's Twitter is in the description. Katie Esquire, please follow her. Please give her a sub. We appreciate you all being here, and we're going to do part 2 of delving into the Dan Markel, Wendi Adelson divorce documents. I have them up ready to go, and my wonderful wife Shannon sent me I asked her to do this while I was streaming last week. She sent me all the documents in date order, so we're going to do this chronologically. We will do a quick refresher of what we went over last week, and then we're going to go through it. I do want to say a couple things because I don't know. I want to kind of stipulate this because particularly for Shannon, it's tough for her to watch sometimes these shows because she herself has gone through a pretty difficult, contentious divorce. And she went through where she moved with her daughter to New York from Kansas, and a lot of times in the chat, people are like, how could you ever move? How could you ever do this? There are just sometimes reasons where it's okay. In this instance with Dan Markel and Wendi Adelson, I didn't think it was okay, but sometimes there are instances where it is. So let's keep that in mind. And, Kay, you said too, like sometimes we were talking beforehand, sometimes parents will stipulate to that, right? If that's the best thing they feel is for their kids.
Yeah, it's so if I travel a lot with work and I'm back and forth to a bunch of different places, or let's say there's something that's available for my kid in Miami that's not available in Tallahassee. Yeah, you might agree to it.
Right. And then secondly, we talk about grandparents' rights and Ruth Markel, and we're always, and I think in this case, I think most of us think in this case, it's awful, awful, awful. I mean, it is. I mean, but in this case, it is awful that they are keeping the kids away from Ruth and Phil and Shelly. However, sometimes there, people gave me a lot of heat on some videos. Sometimes there are grandparents that aren't the most fit to be seeing their kids. So sometimes it's not in both instances, it's a case by case, scenario. So I just want people to, kind of think about that. Obviously in this case, I think it's warranted, but in some cases grandparents maybe shouldn't, and like we were talking about before the showcase, sometimes
I've prosecuted some grandparents.
Right. Exactly. So the parents are the gatekeepers, like we talked about before, and sometimes so just kind of keep that in mind. And then you kind of, Katie, want to talk some about the 50-50 that we talked about in the last stream?
Yeah. So, I mean, 50-50, it would be presumptive in this case where you've got two parents that are involved in their lives and, there's not problems with either one of them. But the answer to every family law question on the Florida bar exam is what's in the best interest of the children. And in this case, I can't find anybody not seeing that the best interest of the children would be 50-50 custody between these two parents based on what they do for a living. But you could find that it's, even without abuse or anything like that it might be in the best interest of the children to be with mom 75% of the time because mom lives right next to the school and dad lives 2 hours away. And it's just, it's difficult. That's why some of these family law cases are very difficult. And usually everybody walks out pissed off,
right?
To be truthful.
That makes sense. And it's a case by case basis. And let's get into this case, folks. So let me bring up the screen here, and we're going to start. Again, I got to thank my wonderful wife who put these all in order. And it's interesting. We talked about, and I'll bring it up. The first document, at least dated in this entire document. Let me bring this up here. Make sure I have the correct code here. Sorry, hold on one second. And the first document, and I just did a video about this, is on page 503, first dated document. And again, what is that? It's the parenting class that Wendi Adelson did. You all right?
Getting comfortable. Getting
it is the parenting certificate of course completion that Wendi completed on July 27, 2012. And that was before September 10th, which is when her divorce was left with Dan, essentially was filed. So just a reminder.
And the 12th was the phone call or the text message whenever he was out of town.
So again, she was clearly planning this, and what a lot of people commented, and I thought about it, is like, how much of this was she planning with Donna and Charlie and the rest of the fam? The Pearl Harbor, as Dan would call it. So this is September 27th. The next date is, and we won't go over it again because we went over it in the first stream, which is in the description if you want to see it. The next date is September 5th is when it was filed. Let me hold on. Sorry, guys. Let's pull it up here. September 5th is the Wendy's petition for dissolution of the marriage, and that is right here. So it's filed September 10th. We already went through this, so we're not going to do it again. But just to get an idea, so remember, she went to parenting, or she filed the parenting class. It was July 27th. The petition for dissolution of the marriage, September 5th, filed September 10th. And
Dan finds out about it September 12th.
And Dan
so
finds
she's opening a court case without telling him.
Exactly.
Which, not technically illegal. I just think it's kind of a dick move.
Big time dick move.
Yeah.
All right. And then the next date in the documents, let me go there, is on.
In this scenario, a dick move.
Right.
I'll correct myself.
Good call.
And he also brings that up too, that, in some cases it might be appropriate to have a Pearl Harbor type, take the kids, take the stuff, leave, because he's beating you or he's threatening to kill you or he's, all these different reasons that might cause you to file for an injunction at the same time.
Exactly. So great call. All right. So the next date is October 12th. Well, at least October 12th is when Dan files his answer to the petition for dissolution and counter petition. It's 10-3, I think, is when it, because I think Shannon did this by when it was written. So 10-3 is when
maybe when he signed it. Yeah.
Dated. Yeah. So, and then it's filed October. So we're going by the dates I'm going to go are by when, actually we could do either way. So, all right. So October 3rd, 2012 is Dan's, when he files he responds, it's officially filed, stamped with the court. Did I have it here? October 12th. All right. Next date is 10-4. Let me bring that up here. And that is, sorry guys, I wish there was a better way to search through these documents as far as, all right, so let's go to, the next date is Wendy's motion for temporary relief. This is filed with the courts October 4th. And I think we did this already. Did we do this already? Well, I think it's pretty quick. We can go through it. So come now, Wendy, through her counsel, files for this motion for temporary relief. She filed her petition on September 10th. 2 minor children. During the pendency of the action, the parties have attempted to negotiate a parenting arrangement for the children. The parties were able to agree upon a time-sharing schedule for the month of September, but are currently unable to agree on any future parenting plan. Wife has proposed various parenting plans to the husbands, to which he has either not responded or rejected. The wife proposes a parenting plan through December 2012 in the best interest of the children, which accommodates both parents' work schedules, each parent's travels plans, as well as the husband's desire to have the children on major religious holidays. The parenting plan provides mother with 51% of the time sharing, father with 49%. It is in the best interest of the children for the court to enter into this proposed parenting plan, which is attached here to as Exhibit A. The children are presently in need of temporary support from the husband. The wife has incurred reasonable attorney's fees and costs and representative of this matter and bring this motion for temporary relief. So this is on October 4th. That was the next date. The next date after that is interesting, and we talked about this, Katie, and we can talk about what we talked about before the stream. So let's go to the next date in the docket is October 15th. And what is that, folks? Let me bring that up. That is a joint stipulation for the substitution of counsel, where Wendi Adelson and her then attorney Shannon Novy, she requests to be replaced by Kristen Adamson. And from your understanding, Katie, why was this?
And I can't cite to the source, so I'm sure the chat will have it, because there's some people that are maybe a little bit more into this case, but that apparently Shannon Novy would not file the petition for relocation because you have to have a good faith basis to be able to file a petition for relocation. That there was some kind of, I guess, impasse between Shannon Novy and Wendi Adelson, or potentially Donna Adelson, about filing this relocation with the children. And, you know, just I often use my cat with the goat cheese as the example. Like, just because I've never given you goat cheese off of my pizza for the last 17 years you've been alive doesn't mean today's not your lucky day and you're not going to ask for it. You can ask for it, but if you know that you have absolutely no ability to win this, like, you have to have a good faith basis to file a motion. And I believe that there was some testimony, and I think it may have been from Wendi even in the last trial, that her first lawyer said that there was no way they were going to win that and wouldn't file it. So anyway, this is joint stipulation, substitution of counsel is filed, and then I think by December there was a petition to relocate with the children.
Yep. So basically, essentially, Wendy's first attorney's like, I'm not filing that. Sorry, we're not doing that. And Wendy's like, all right, well, I'm getting a new attorney. She gets a new attorney. So this is October 17th when the new attorney is stipulated in. And before Wendy's, I'll show you guys the next document, which is pretty interesting. The next document chronologically in this is, check this out. This is page 530. And
I'll also interject this. So Wendi was barely, like, she was still in school when she married Dan. She was pretty young. She was 26. She got a master's degree in between college and law school. So she was pretty much in school the whole time. And she had these kids like 15 months apart. They are like less than Irish twins. So she had, like, what, 6 months between them that she wasn't pregnant.
Right.
And they're both boys, and boys are nuts. No offense.
Yeah, I have two. I agree.
Yeah. And so they're toddlers now. And I'm sure her mom was very helpful, and I'm sure it was incredibly overwhelming.
Absolutely. All right. So the next date, folks, the next document that's dated in here is, and this is attached to the next motion, which I'll show next, but here it is. On December 3rd, 2012, there's an email in the documents that is from, you can see this is the new attorney, Kristen Adamson, and this is from Neil Roth, and it is a firm. This will confirm that our firm has offered Wendi Adelson a position with our firm, which will pay her $115,000 per year. Additionally, bonuses may be paid at the discretion of the compensation committee. And where is that firm, folks? Coral Gables, Florida. So that was the next document that's in there.
And I'll also interject, Coral Springs is different than Coral Gables. Coral Springs is in northwest Broward County. Coral Gables is in southeast Dade. So it's a good 1.5 to 2 hour drive between the two.
Oh, awesome. All right, awesome. So there you go, folks.
Yeah, so, just because it has coral in it doesn't mean it's close.
See, I did not know that. All right, so
Coral Springs is actually just below Parkland, if y'all are familiar with that case, in Broward. And then, like, Coral Gables is way down south Miami, almost into, like, just above Key Largo, essentially.
All right, awesome. All right, so that's the job offer, which this email, as you can see, is dated December 3rd. What is next after that? Let's go to page 422. And then now we're going to start getting into stuff I do not believe we got into last. Well, we're already into it, but here is, so 2 days after that email that was sent is Wendi Adelson's wife's answer to the husband's counter petition for dissolution of marriage. Comes now wife Wendi Adelson. Let me make this. Hopefully you guys can realize a little too. All right. Comes now wife Wendi Adelson by and through the undersigned attorney and files this answer to the husband's counter petition for the dissolution of marriage and states the wife admits allegations in paragraph 1, admits in paragraph 2, admits in paragraph 3. So agreeing to some of the allegations that were in Dan's. So all these are admitting to allegation. The wife admits allegations in paragraph 8, but denies that the wife should be required to maintain life insurance on her life in an amount sufficient to meet her child support obligations in the event of the wife's death. The wife denies allegations in paragraph 9, admits the allegations in paragraph 10, but denies granting to the husband at least equal time sharing with the minor children. So no equal time sharing. She doesn't want it. The wife admits that during the course of the marriage, the parties have acquired certain real and personal property, both tangible and intangible, as well as other assets and debts, all of which require this court's determination as to marital status, valuation, and division. The wife denies the remaining allegations contained in paragraph 11 of the husband's counter petition. The wife denies the allegations in paragraph 12, and that is the next document. Again, this is December 5th. And that is her response to Dan. What happens next? So this is December 5th, and this is the next motion, which is January 14th. And this motion is a biggie, folks. So let's go here. This is page 417. And here it is, folks. The biggest deal. Again, this is about a month after that, right? So the last motion was December 5th, 2012. This motion is January 14th, 2013. Motion for temporary relocation with a minor children pending final hearing on relocation. Come now, Wendi Adelson moves this court pursuant to Florida Statute 61-13001 for an expedited hearing, allowing her to temporarily relocate to Coral Springs, Florida, pending final hearing on her relocation request, and would state, the wife filed her petition for dissolution of marriage on September 10, 2012. The husband has filed his answer. The wife filed her response. On January 14, 2013, the wife has filed her motion to leave to amend her petition to add a relocation request together with her proposed petition for relocation. The wife.
So to add that.
Go ahead.
It wasn't asked for originally.
Right. So initially she files the thing. Her attorney's fine with it. They file it. And now her new attorney's like, oh, we're going to add this to that original one saying we want to move.
I think it was in one of Wendy's testimonies. I just don't. I mean, she's testified so many times that.
Yeah. So the wife requests that this court grant her an expedited hearing. So she wants an expedited hearing pursuant to the statute, an evidentiary hearing on or non-jury trial on a pleading seeking temporary or permanent relief filed under this section shall be accorded priority on the court's calendar. If a motion seeking temporary relocation is filed absent good cause, the hearing must occur no later than 30 days after the motion for temporary relocation is filed. If a notice to set the matter for a non-jury trial is filed absent good cause, the non-jury trial must occur no later than 90 days. So basically, she's like, let's get this. This is important. We need to get this done. The wife requests she be allowed a temporary relocation with the minor children to Coral Springs because she has been offered a job, which we went over that.
In where?
Coral Springs.
What does the job offer say?
I forgot. It said the other Coral, didn't
Coral Gables.
Oh, pretty interesting, huh, folks? Pretty interesting. So different Corals.
So anybody who's really interested in this case, pull up a map of South Florida, and you also have to kind of be aware of where the highways are too. It is like a 2-hour drive from Coral Gables to Coral Springs.
I could probably do this now. Hold on.
But you don't need to. I'm just
okay. All right.
pointing it out that that's it. I think that a map of South Florida is probably going to factor into this, or should factor into the state's hearing or the state's case this time.
The wife requests she be allowed temporary relocation with the minor children. Substantially greater income beginning May 1st, 2013. The wife must inform the employer of her ability to relocate and accept this position on a very short notice. The wife requests this court consider her motion and her petition and grant her a hearing so this court can allow her to relocate with the minor children and meet this deadline. Wherefore, the court respects an expedited hearing, allow the wife to temporarily relocate to Coral Springs with the minor children and accept her new job while the case is pending. So, I mean, when Dan gets this to me, he must be like, are you out of your freaking mind right now, right, Katie? I mean,
Yeah, and I wonder if he didn't catch the Coral Gables versus Coral Springs, because remember they lived in Miami for a year,
Right.
and the University of Miami is in Coral Gables, and he had been to our house in Coral Springs. So I get the feeling he probably picked that up.
All right. So the next, this is motion to leave for the amended petition of to add a complaint for. This is basically just the actual motion that's adding the amended petition for the to add a complaint for the relocation. So I don't know if there's anything. So that's just adding the complaint. All right. So and then what after that? Motion to add. Oh no, that's sorry. All right. So 522 is the. Oops. This is the amended petition. So I think this is just the entire petition. So this is the original petition with the additional request, the amended petition with the request to move, which we already went through the initial petition, but this includes the relocation, which wife, and here she puts the wife has been offered a job in Boca Raton.
Now, Boca Raton is in the southern part of Palm Beach County. It goes Dade's Monroe is the Keys. All right. Then you got Dade, which is Miami-Dade County. They hyphenated it. Broward is Fort Lauderdale, Coral Springs, all these cities. And then Boca is right over the Palm Beach County line. So it's possible that Dan, sent back a what the fuck. We both know you're not driving. Like, you can pay me to drive from Coral Springs to Dade County every day.
Interesting. All right.
Couldn't pay me enough.
And we have some additional reasoning in here. Is the specific reason for the proposed relocation is that the wife has been offered a job in Boca Raton, paying her substantially more in salary and year-end bonus than her current job as a clinical professor. The job offer for the position of an attorney with Grossman Roth PA is reduced to writing and attached here too. We saw that. The wife also desires to relocate to South Florida in order to provide a better quality of life for the children by increasing their access to close family and providing more stability and consistency. Yeah, I mean, as we know, the Adelsons, that's the complete opposite. By contrast, the wife's parents reside in Coral Springs, and the wife's brother resides 20 minutes away, folks. It's all in here.
20 minutes is, again,
a stretch.
That's massaging the truth with South Florida traffic. Like maybe it's 20 minutes away at 3:00 in the morning.
Right. So interesting. That guys. So this is January 14, 2013, and we're already bringing in that Wendy's got to move. It's better for the kids to be by her mom, her family, including Charlie. Interesting that it doesn't say her family. It says her mom and her wife brother resides 20 minutes away. The children are very close to the wife parents as they have visited every 3 to 4 weeks since the birth of the child. Furthermore, the husband travels a great deal, approximately 45 to 55 days away from the family each year. Second, the husband and wife both work for Florida State University of Law. The husband is a tenured professor, while the wife's position is on a non-tenured track and a more tenuous one. The husband has indicated to the wife that her employment at FSU Law School is solely dependent upon his discretion. The husband, here we go. This comes up in the trials. The husband has also created a hostile work environment for the wife at FSU School of Law by telling the administration and their joint colleagues that the wife has stolen from him and that she has mental health issues, isolating the wife in Tallahassee's small legal community and further limiting the wife's career prospects in the area. The husband has been constantly dropping into the wife's office unannounced, uninvited, and undesired. The husband continued to do so until asked to stop by legal counsel. And this just makes me think of when George is like, them some fighting words, right, Wendy? And when he's like, I don't know what you're talking about. Finally, since
arriving, you mean the contempt?
Oh, the contempt. Yeah, that
yeah.
You're right.
When she didn't know what contempt was.
That's true.
I call BS on that one too.
Yeah.
Like I understand that she was let go from University of Miami because she wasn't that great of a lawyer, but first-year law students know that.
Finally, since arriving in Tallahassee in 2005, the husband has indicated his intention to seek employment at another law school outside of Tallahassee. He was consistently through the years he has consistently through the years sent out resumes and has at one point even accepted a position at another school, which then fell through. With no roots to bind either party to Tallahassee other than the husband's position as a law professor, the wife believes that the party's time in Tallahassee is tenuous. These facts demonstrate an unstable environment that does not serve the best interests of the children post dissolution of marriage. The wife seeks more consistency and stable employment to improve the quality of life for herself and her children. The wife proposes that the party's timeshare be 60-40, as the husband has access to his great uncle's 2-bedroom apartment in Hallandale, Florida, and
Southern Broward.
Southern Broward, and his aunt and uncle's 3-bedroom apartment in Pembroke Pines, Florida.
Southwest Broward.
The husband has a very flexible schedule so that he can come to see the children as often as he would like to for extended periods of time. This is like insane. Like, so, okay, Dan, this is what we're going to do. I'm going to move, and then you can hang out with your aunt and uncle and then see them then kind of, when you want to, because we'll just let you do that whenever you want. Right, Wendy? The husband has a very flexible schedule that he can come to see the children as often as he was like for extended periods of time. The husband only has teaching responsibilities 2 days per week during the fall and spring semester and does not teach during the summer semester. The wife proposes that during the school year, the husband come to South Florida every Saturday through Tuesday, and in the off week come for at least 2 days to see the children. The wife also suggests alternating the major holidays and extended time for the husband with the children in the summer. The wife proposes that for these extended times, the children travel to Tallahassee or wherever the husband is living. The cost of transportation should be shared if it is not otherwise paid for by the husband's employment. The court should consider the following in making its determination: the nature, quality, extent of involvement, and duration of the child's relationship with the parent or other person proposing to relocate with the child and with the non-relocating parent, other persons, siblings, half siblings, and other significant persons in the child's life. So they're like quoting statute, right? To like, and then
Right.
they're gonna say why. The wife has an extended family and friends in the South Florida area, and the husband has no family in the Tallahassee area. The minor children have no other siblings. The children are close to both parents. The age and developmental stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child.
For example, child has severe autism, maybe moving to a larger city with better treatment for that, medical conditions, those kinds of things that sometimes parents will agree to it, that, yeah, the kid's better off in Atlanta.
Right. That makes sense. The relocation will not materially impact the children because they are not yet school age. They will be allowed to emotionally develop and will have more support from extended family relationships. 3, the feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as the financial circumstances of the parties, whether those factors are sufficient to foster a continuing, meaningful relationship between the child and the non-relocating parent or other person, and the likelihood of compliance with the substitute arrangements by the wife, relocating parent, or other person once he or she is out of the jurisdiction of the court. I mean, so is Wendy going to really follow once she moves? Is she going to follow what's going on here? The wife will comply with all substitute arrangements, and the parenting time for the husband should be as extensive as his employment and health will allow. The husband suffers from Crohn's disease,
Not how you spell Crohn's, for the record.
Persistent episodes of vertigo and back problems that resulted in December 2012. When any combination of these issues arises, he is unable to care for the children on his own. So basically, she's like, they should be here because Dan is sickly, and he can't. I can handle it better. The child's preference, taking into consideration the age and maturity of the child. The children are too young to voice any preference. whether relocation will enhance the general quality of life for both the parent or other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities. The quality of life for both the wife and the children will improve greatly because the wife will have a better, more consistent job, the help of extended family, and the children will have increased access to extended family as well. 6, the reasons each parent or other person is seeking or opposing the relocation. The wife is seeking to relocate for a better, more stable job and to have the children grow up in a stable and consistent environment and not repeatedly relocate across the country as the husband moves for forever better positions. So this is
That should be hyphenated. I'm sorry, I found so many like minor typos in these.
no, that's all right. So these are all the 7. The current employment and economic circumstances of each parent or other person, and whether the proposed relocation is necessary to improve the economic circumstances of the parent or the other person seeking relocation of the child. The wife's employment is going to be considerably better with this move. The husband has no intention of staying in Tallahassee and has consistently expressed his intent to move to a much larger city and more prestigious school. The husband has considered Miami, Houston, New York, Washington, D.C., and St. Louis among his choices. 8, that the relocation is sought in good faith and to the extent of which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking relocation, including child support, spousal support, and marital property and marital debt obligation. The wife is seeking this relocation in good faith. Okay.
And I'll tell you, $115,000 a year is not much in South Florida, even 10 years ago.
Interesting. 9, the career and other opportunities available for the objecting parent or other person if the relocation occurs. The career opportunities for the husband are the same regardless of the wife's relocation and will create a situation where the transportation is even better for the husband when he moves to a larger metropolitan area. 10, a history of substance abuse. This is not applicable.
Wife at least that was pitiful.
Yeah, wife has retained Kristen Adelson to represent her in this cause and agrees to pay a reasonable fee for her services plus suit money and cost based on the relative financial circumstances of the parties. Husbands should be required to pay or contribute to the wife's attorney's fees. Man, that is wild to me that she's like, I'm filing all this shit and I want you to pay for it. I mean, a response to the petition must be made in writing, filed with the court within 20 days. So what do you think about that? What do you think about that, Katie, that document there?
Well, I'll bring in a little bit of extraneous information too. I seem to remember that what Kristen Adelson was charging hourly was very high, or at least to me seemed very high. As of 10 years ago in Tallahassee, Florida, I think it was like, I don't know, it was like $550 or $600 an hour. So having, forcing him to contribute to the legal fees, that must have been like an extra, turning of the knife that
right.
Essentially these are pretty high for legal fees.
Interesting. All right. So the next documents are Wendy's compliance for mandatory disclosure. So I don't even know if we have to go. I'll bring it up, but let's see. That's 504. This is just basically her attaching her wage documents, or which we went over all this stuff. I don't know if we need to. The deed is in the husband's possession. So this is just going through what she provided in the affidavit, which we...
Wait, go back up?
Yeah, sure. What do you want me to go?
Wait, down a little bit. There was something about... Okay, Charles Schwab's statements. Keep going. There was something about... Go down a little further. Group insurance. Okay. No, there was something about credit cards.
Let me start at the top. So there's the income tax returns, pay stubs, royalty. Oh my God. Statement from the royalty income from This Is Our Story by Wendi Adelson. Deed for the
I didn't catch that one, but that's interesting.
Yeah. Checking account.
Checking account.
This is the Charles Schwab statements. Oh, is this what you're looking for?
Yeah. All credit card and charge statements and other records showing your debts as of the date of filing of this action in the prior 3 months. Okay. Amex Business Platinum. Parents card.
Interesting. Good catch.
That's what I said. I saw a parents card and I was just like, you gotta be kidding me. And charges dating from 8/7/12 to 12/10/12, totaling $7,246.81.
So for 4 months,
So she has an Adelson Institute credit card. Is my question?
Interesting. Amex Business Platinum card, right? That's got to be what that is, right? What else would that be? Parents card from August.
Advanced City MasterCard account number, and I'm assuming what's blacked out is going to be the last 4 digits of the account, is what I'm assuming. But parents card
again, the parents card. 4 cards that are the parents card. Chase mileage parents card. These are all of these are her parents' credit cards.
Well, I don't know if they're her parents' credit cards, but certainly she doesn't have an Amex Platinum business account. I mean, it looks like these are all her parents' credit cards. That's
what parents' card mean, right? What else could I mean?
Yeah, you're trying to say it's like, oh, it's me as a co-parent to the children, but I don't see how that could be anything other than that. Especially when you look at the Amex Business Platinum, because nobody who's a law professor is going to have one of those,
right?
And also, I'm like, why would she even get a card for the Adelson Institute? She's not a dentist. She doesn't work there.
This is interesting. We can go to the affidavit. I guess I'll just say the same thing on the affidavit, so we won't know whose it is exactly.
Yeah, sorry, I saw parent. I go back.
No, I'm glad you said to do that. Copy of the lease from Aqua Ridge, which is where she drove from to go by the crime scene. Dan's house. Premarital IRA. All right, so that's January 22nd, 2013. And we can go to this is, I think we went through this. This is the document we went through last time, which has...
Oh, wait, go up. What is she trying to say she makes? She makes $85,000 annually in Tallahassee as a professor. Now, Dan says in later pleadings that she understated her income quite significantly. But let me tell you, $85,000 a year in Tallahassee goes a hell of a lot farther than $115,000 a year in South Florida.
Oh, that's
even back then. And keep in mind, I lived down there back in 2014, 15, 16. I was paying 10 years ago for a 1-1. I was paying like, I don't know, $1,650 a month. And now the same place is renting out for $2,500 a month. And I was like living hand to mouth on a prosecutor's salary of under $80,000 a year. And like no, like paycheck to paycheck type living. And on 80. And so she's going to raise 2 boys and commute and pay for a car, because I owned my car outright. It was a piece of shit, but I owned it. But like, I just don't see that. How are you possibly going to live on that?
That makes a lot of sense. All right, so this is the RAs, but this doesn't say anything about... Interesting. There's nothing on the sheet she made. Let's see. So she doesn't put on the sheet anything about those accounts that I saw.
Mm-hmm.
And it was like $7,000 in 4 months. What the hell was that about? That's interesting. No, that she put it in that document, but it's not in this.
Because those would be monthly liabilities, wouldn't they?
Yeah. So she's got the checking. All she's got is the checking. Wendy's the wife's probably, and wife's Regions checking. Husband's Schwab. Then the real estate, then the retirement and IRAs. She's got... That's really interesting. All right, liabilities. There is nothing, and she puts all... This is all zeroed out, which we read. Dan was like, "What is that about?" There is nothing here about that what she put in that. Her liabilities are 0. Pretty interesting.
Yeah, I recently traded in again a piece of shit car with like 200,000 miles on it, and they still gave us like $1,000 for it. There's Kelly Blue Books out there.
This is pretty interesting. All right, so this is January 22nd, 2013. The next document is the stipulated order to amend request of dissolution. So let me see if we need to even look at that. So that's this is stipulated. This cause coming from before the court. The wife's motion to leave to amend for petition is to add the wife's motion to add the relocation is granted. The wife's petition for dissolution is accepted and timely filed. The husband shall have 20 days from the date of the stipulated order to file a responsive pleading to Wendi to the wife submitted petition. So that's 1/29/13. And folks, now we're going to take a look at Dan Markel's response, and that should be interesting. I wonder if this is what we went over last time, but we'll do it again, even if it is. And so let me try to find that. That is on page 427. So let's see. All right. So here Dan gets that, and Dan is responding. Comes now the respondent husband, Daniel Markel, and files this answer. It's 23
pages.
So we'll probably finish it on this.
And it's probably been, I have to imagine that his lawyer chopped it down.
Yeah. He admits to certain allegations in the beginning, 1 through 3. The allegation in paragraph 4 is denied. The wife has abandoned the husband without exploring adequate alternatives to dissolution of the parties' marriage, including counseling, and she has determined precipitously the marriage is irretrievably broken. Oh man, I bet you Dan's gonna have some big words in here, and I already had someone comment that about my the way I speak, so they're not gonna like this one. If you hear, sorry if I mess up some of the words. The allegations in 5 and 6 are admitted. The husband denies allegations contained in paragraph 7 of the amended petition. The husband and wife have, since their separation, shared parental responsibility and time sharing equally. However, although the husband seeks continued equal time sharing in Tallahassee, he seeks sole parental responsibility on issues related to the education, religion, and medical upbringing of the children. The allegations contained in paragraph 8 of the petition are denied. The husband affirmatively alleges that the parties have been exercising equal time sharing since the wife's abandonment of the parties' marriage and marital home in early September of 2012. Moreover, prior to the wife's abandonment, the parties enjoyed equal responsibilities regards to all, caps, bold, underlined, aspects of their children's lives. Any claim that the wife should have more time sharing than the husband is baseless and unjust. 9. The allegations contained in paragraph 9 of the amended petition are admitted. The husband alleges that child support should be calculated in accordance with the child support guidelines in the state of Florida, taking into account both parties' incomes and time-sharing schedules established by this court. 10. The allegations contained in paragraph 10 of the amended petition are denied. The husband affirmatively alleges that the wife has no ongoing need for any alimony of any nature from the husband. The wife expressly told the husband on September 11, 2012, that she neither the need nor desire for alimony because she has a well-paying job, and since September 2012, the job has only increased in pay and stability. Moreover, the wife has incurred unjustified expenses in part by moving post-separation to a newer and more expensive 4-bedroom home compared to the more modest 3-bedroom marital home. That's pretty interesting, huh, Katie?
Yeah, well, I mean, when she wrote down what the rent was for her home the last time, and I think she said it was $2,000 a month, and I was just like, that seems really high for this area. But it's entirely, I mean, I haven't been inside the house, so maybe she moved to a nicer house.
So she moves. So basically, he's like, you moved to a bigger house now, and now like we had a 3-bedroom. You moved to a newer and more expensive 4-bedroom home. Mm-hmm. As the allegations contained in paragraph 11, the husband admits that the parties own real property, tangible and intangible personal property, and liabilities which require the court's determination as to marital status and valuation. but he denies that the wife should be entitled to a 50% distribution of same. Further, the husband affirmatively alleges he should be entitled to a greater share of the assets, as he is primarily responsible for their acquisition during a marriage in which both parties worked full time. As to the allegations contained in paragraph 12, husband admits that the parties have obtained certain assets and incurred certain debts and liabilities during the course of their marriage, but he denies the assets and debts should be evenly distributed between the parties. Rather, they should be distributed with the attention to the manner of acquisition. All right, we're about to get to the good stuff. The allegations contained in paragraph 13 are admitted. The husband alleges the wife helped her. Oh, this is big. This is a big deal. The husband further affirmatively alleges that the wife helped herself to non-marital assets, including money and stocks owned prior to marriage, as well as numerous personal non-marital belongings to the husbands, such as his luggage, bicycle, tennis racket, and family heirlooms. We've heard about that tennis racket in court. The wife has refused to return these items to allow the husband into her home to see what other personal belongings were taken without his permission or acquiescence. So here Dan's starting to get into, she stole from me and she's not giving me back my stuff. Family heirlooms, the ring. We heard about the tennis racket. His luggage, his bike. She took all his shit, is what he's saying, essentially.
And bicycle, so I know that both of them, I know Wendi did some kind of a marathon. I'm just going to throw this out there. I don't know what kind of a bicycle he had, because some of these bikes for triathlons, I mean, several hundred up to $1,000.
Yeah. So, all right. So here we go. Objection to the wife's request to relocate with minor children. Once examined in context, the sole, all caps, bold, underline, stated reason the wife seeks to relocate with the party's minor children is that so she can be closer to her parents. As the court stated in Coyle vs. Coyle and in numerous other cases, relocation cannot be based simply upon finding that the relocation would serve the best interests of the relocating parent. Fredman versus Fredman. Affirming the trial court's denial of relocation because the relocation was found only in the mother's best interest, but not in the minor child's. And now we have a little footnote. Let's see what that's about. In January 2013, electronic communication to the husband, wife claimed that she thought relocation was in the best interest of our kids to be closer to family, more access to a Jewish community, and a happier mom. She doesn't mention the economic rationale at all, which lies at the heart of her filed petition. And her written petition doesn't mention the Jewish community at all, because the facts are the wife has done nothing to facilitate the children's connection to the Jewish community since the separation. She not only introduced them to a non-kosher diet since the separation, but on her weekend, she refuses to allow husband to continue their pre-separation practice of bringing the children every week to synagogue for services and Sunday school, notwithstanding that the husband has offered wife time-sharing offsets in exchange for allowing that to happen. Accordingly, the only reason for the relocation are happier mom and more access to the wife's parents. Pretty interesting, huh, Katie?
Yep. And obviously he's kept all these emails, and I will tell anybody in the chat that both of my parents, who are lawyers, taught me this at high school. You can say it with roses, you can say it with mink, but for the love of God, kid, don't say it in ink.
Yeah, so when he's putting
you put stuff in writing, people are going to throw it back in your face.
Yeah, that's why he's putting in quotes, right? He's like, listen, yep. This is not just me making this up. I have proof of this.
Keeping the receipts.
Relocation was found in the mother's best interest, but not in the minor child's. So this is going over why a relocation request because any evidence regarding to the benefits of relocation related to the mother and her new husband, and there was no evidence that. So this is case law basically saying that Wendi can't relocate. The husband currently lives in the party's marital home, which the wife, with children in tow, stealthily and abruptly abandoned in September 2012. The wife currently resides approximately 10 minutes from the marital home, and both parties live approximately 15 minutes from their children's preschool. The preschool is also 10 minutes from the FSU College of Law, where both the husband and wife are employed. I'm going to go past that. That just says their name, the kids' names. Prior to the wife's abandonment of the marriage and home, the husband was actively involved as a father. The husband and wife both work at the FSU College of Law in jobs that provide significant flexibility and the opportunity to care for the children. After the birth of the party's first son, the husband had a light teaching load in the fall of, I'll go back to that, 2009. Following the birth of their second son, he was permitted to take a semester of parental leave in the fall of 2011. Throughout the children's lives, the husband has been immersed in parenting, routinely taking them to doctor's appointments, cooking for them, bathing them, and visiting them at their preschool for circle time and daytime meals. He is, in short, an integral and positive part of their daily lives. Let's go back to that footnote.
Yeah.
And then I think we'll end it there and we'll continue when we do our next session. All right, so let's see what we got here. On September 10th, 2012, after 2 days of not answering husband's calls or texts, the wife urgently called husband while he was on a short business trip in New York City and told him for the first time and over the phone that she wanted a divorce, notwithstanding the absence of any infidelity, abuse, or neglect by either party. He begged for her not to do anything until he returned, and that he would be on the next flight home. Arriving at home that night, he was shocked. Wife was gone. The boys were gone. The house was half plundered. The Schwab accounts had been raided, and divorce papers were left on the bed. Most importantly, there was no indication of where the wife and children were. Worse, for the first 15 days of the separation, wife refused to give her husband any address or phone number for where she lived with the children. Thus, when the children were not with the husband or at the preschool, the husband had no idea where his children were. On September 25th, 2012, the wife finally answered the husband and his counsel plea for a proper address, but she gave him a false address that wasn't corrected until 4 weeks later.
That's news to me.
That's
the false address. I knew it was 6 weeks he didn't know where they lived, but the false address is insane.
So,
and again, there might be situations where this is appropriate. Like if somebody threatens to kill you and your kids, no, you're not going to say, here's where I'm taking them and here's the hours they'll be there in case you want to follow through on that.
Right. Exactly. All right. So let me, I'll finish this page because so I know which page we stopped on, which is page 6. E. Since the parties' separation, the parties have had equal 50-50 time sharing with the minor children. Since October of 2012, they have had an alternating 2-2-3 time sharing schedule with adjustments and offsets made for travel, work, and other preferences regarding holidays. This rotating time sharing schedule effectively provides each parent with 7 nights of every 14 with the children. Additionally, the parties have agreed on a communication schedule for time apart and a condition that allows both parents to regularly spend time with the children at their preschool during the week to facilitate ongoing and continuing contact with them. Therefore, since the party's separation, the husband has effectively had access to and visits with children 12 out of 14 days. Conversely, and importantly, because the husband is committed to including the wife in the life of the children as much as possible, the husband has offered the wife greater access to the children than she has been given by offering Skype calls or in-person visits on any day he has the children so that the parties can co-parent. Unfortunately, to date, the wife largely ignores the children on the days and evenings that she does not have responsibility for them. Pretty interesting, huh, Katie? So he's like, even he's alleging she ignores the children on the days and evening that she does not have responsibility for them.
Well, she's off the clock.
She's right? Right. So he's like, are you going to Skype the kids? You have the kids. You want to talk to them? Do you want to, call them? And he's alleging she's not to be found.
Mm-hmm.
So pretty interesting. So, all right, guys, this this has been part 2. Any thoughts, Katie, about what we've gone through today?
I there's plenty of reasons to shame Wendi other than the parenting. So I don't want to go into that, but I that's why when I say this, I don't mean to do that. But she was pretty young and she had these 2 kids just like dropped in her lap. I mean, so quickly, and no parental help or anything like that. When she's used to all, I could see why she was, not wrongfully, I think, but I could see why she was so pissed off. She couldn't move back to Miami. You've saddled me with these kids. You saddled me with Tallahassee. This wasn't my choice, and I'm trapped here. Now, but the solution is you move to Miami and you travel. And she wasn't willing to do that.
Very interesting. Very interesting. Yeah, so I hope you guys have enjoyed this deep dive into the document. Sorry if I butchered some words. We had over 325 people in here. We really appreciate you being here. Please, please, please follow Katie on twitter.com. And we're going to do this again. And after I end this, if you guys didn't know, there was a new affidavit for a search warrant in Donna Adelson's case. And me or Katie are going to discuss it for a little bit. And I'm going to put it on Patreon so you guys can check it out. Thank you all so much for being here. And again, Monday, I didn't say again, but we love you, Katie. Folks, Katie, I just have to say some of the best comments I get. People love you, Katie. They love your commentary. So I got to thank you so much for continuing to come on with me and do this. Even with a sick kid and a kid that probably got you sick, you came on and did this. So I really appreciate it.
Yeah, no, I'm anticipating I'm going to go downhill this week pretty quick.
Well, we all hope that you don't. And what was I saying? Oh, so Monday, folks, Karen Reed trial starts. When I end this, it's going to take you to that stream. If you could just like it, get in the algorithm. If I missed, the worst thing that I hate the most is I always miss all the people who did super chats and stickers. If you did it during the chat, thank you so much. I appreciate it. Thank you, mods. And we'll schedule another one of these. Hopefully, Katie feels all right, but whenever she's all right and feeling okay, we'll schedule another one. So thank you all so much, and we'll catch you on the next one.